All right. Good evening, everyone. I don't normally do a Monday night show. Usually Kirk does the Monday night show, but I have some information I want to share and go over with you guys tonight. Seems pretty important in context based on where we're going, what we're doing, what's up on the board over my right shoulder here. And one of the reasons why this ended up I think there's a part of this process that kind of went over some people's heads. So I want to kind of go over and cover that a little bit because it's kind of important on knowing and understanding, when we talk about where you're standing in law and why. So without further ado on that, let me yank up the document here and all right. So remember, in context, when you're going over the whole process of where are you filing your document? Okay, first three rules of real estate, right? Location, location, location. Notice that this is in the office of county commissioners. It's not in any court. Okay, so when we talk about where is our political standing, and good evening, everyone. I wish if I can ask everyone to share, because I am just going to kind of step into this and try to get through it. So when we're talking about where is our political power, where is our standing in law, right? Where can we do the most harm or most harm to the bad actors and most help for good actors? Well, that's in the House of Politics, because the Constitution clearly says all political power is inherent in the people. One of the questions that has come up is in context of, litigations. Well, what's the difference between the House of Congress and the court? And the court has taken the standpoint that they want to create this fictional license, in essence, create law, and literally run their own government, in essence. And looking at the design of the Constitution, the court is designed to be the smallest of all of the branches, right? So Kirk's discussed this, I've discussed this, John's discussed this, we've all discussed this. So when it comes to when we're litigating in courtrooms and they say, well, you have to have this license. Well, folks like myself and John and some various other people, well, hey, dude, I have a license. My license is in commerce. I'm incorporated into the state. So you want to play license, I can play license with you, but that doesn't change anything about the subject matter, the circumstances, who did what to who and when. You see what I'm saying? All of these various things. So we end up litigating more over dumb shit than we end up litigating the facts and the circumstance, the actual meat and potatoes of the case. So go back up to here, because we already know all of our political power is in the legislature, the Article 1 branch, right? So to begin the process and claim what jurisdiction you want to act, you're going to act in, such as the jurisdiction that I'm acting in, originally started as 42 USC 1983. Well, pursuant to the federal orders that we've gotten from judges, and they've saying, well, since you can prove negatives, why don't you use this 28 USC 1443 and build in a safety mechanism? Which, of course, I said, yeah, not only is that reasonable, that's totally logical. So, again, not something that they're used to. They're not used to actually people speaking with them, communicating with them. They issue a lawful order and we follow it. we know no jurisdiction meaning, NO means NO, not KNOW, for God's sake. So all of this crap is starting to come up within the process as we go through and say, oh, by the way, where the hell is this emolument? And what the hell is this law here that's not Republican in character or form? If you don't understand what Article 4, Section 4 says, well, we can implement such things as legal maxims. To know a thing and to be bound to know it are regarded in law as equivalent, which is the reason civics is supposed to be taught in school, that our constitutional republic is based on 3 pillars of law. And of those 3 pillars, the branches are legislative, executive, judicial. So back to that, let's get back into context here. So when we're talking about in the matter of, right, in re, which is in reference to, or in the matter of, and this is where it starts to become real key. Now, I'm addressing this to where normally you would see a judge, Commissioner Kathy Bryant. She is my actual representative in the Office of County Commissioners. Okay, so this is getting to know who is your representative in government. This has nothing to do with the Bar Association and everything to do with the defects in the law. So guess who else has a concern about any defects in the law or any form of her government, anything within her jurisdiction? She wants to know about this. So, if we don't go in there and instruct them lawfully, and I can't stress this enough, lawfully, apply logic, reason, all of these principles we teach on our show. I have to enunciate simplistic things, even for her, which is one of the reasons why I want to do this for you guys. And this is me as now the plaintiff by appellate mandate. Okay. And I have shown the mandate, and I believe it is, I don't have it pulled up here on the screen right now, but I'll pull it up here in a minute. But that's where it says in case style. It's the one document, right? I think it's this one right above my head here that says in case style, it's me versus this Department of Revenue, not the other way around. Okay. And they are claiming they're acting on behalf of my ex. And because of the no jurisdiction order by the Supreme Court, that claim and standing is in error. So this is why when you're actually constructing the heading of your document, start at the top left and go all the way down to the bottom right? It's not just a kind of a haphazard thing. You need to really pay attention and think about what you're doing, why you're doing it, where you're standing in law. And because we're so used to, going in the court of blah, blah, blah. Well, now we're in the Office of County Commissioners. This is where we assert our political power. So when we get orders that say no jurisdiction and why, okay, when we get orders that assign a mandate and standing and why, or in this particular case, it doesn't, the appellate mandate doesn't say why. It just says what it says, because even the Supreme Court decision says, well, the appellate court didn't issue an opinion. So all we know is by the mandate and standing, it's me as the plaintiff versus them as the respondent. You see what I'm saying? So here's what happens. Unfortunately, that backs the appellate court into a real bad position. Okay. And this is one of the reasons why I've involved Ashley Moody's office and, all these people that are in the certificate of service. Let me go over that with you. Again, because the court knows that I've advised my oversight committee, okay, I know how to follow due process of law. I think I've proven that. So, as far as where these actors are and where they stand in law, they have no standing in law. But because this department is claiming that this is their representative, I'm still serving them. even though they know, well, I really, technically speaking, don't have any standing. Well, again, the reason that I assigned the Florida Attorney General Ashley Moody's office outside of the box was because I wanted to make sure that I included all of the legal mumbo jumbo Florida statutes and the, Title 18 USC 1443, proving a negative, and of course 2403, which is, more relative towards petitioning in DC, right? These guys. So that's one of the reasons why I've assembled my certificate of service as I've assembled it. Remember, everything that you do, you have to have a logical and reasonable explanation for doing what you're doing. So knowing that this is in the plain English, which is why it is in all caps, the reason this is in case sentence structure is because these are legal principles, or legalese, as you're going to hear them referred to. That's starting to come out a lot because I'm using it a lot. So, you can expect that. Remember, I've said this since I started. This is the one job on the face of the planet I didn't want to do. But if I have to come in here and do this and correct this record, somebody's ass is in for it. Well, this is where somebody's ass is in for it. So, the writ of deceit, of course, which is, let me go down to the definitions here. I did cover this on one of the shows, so some of you will recognize it. This is a writ against one who deceives and damages another by acting in the other's name. Okay, so that would be, as the respondent, these guys. Okay, so in context, when I go in and I explain this to Miss Kathy Bryant, who is my representative in this office of the county commissioners, you see how this is starting to come together and why. This legal principle here, this decujus, well, as you can see, it is from Latin, meaning from whom. Who is this person, right? According to the second definition, the person whose legal position is an issue. Remember, I've got a problem with this person based on that malicious design in the diagram I've shown. And based on availability of what we already know through that's already taken place throughout the process, what's happened, trespass, blah, blah, blah. Again, that's deceit, or here is the Latin principle meaning of deceit. Okay. Again, a writ available to a party who was deceived and damaged by someone acting in the party's name. So that is further clarification, acting on behalf of, in error, my ex. They're claiming and exercising something they don't have power to do. And we know that because the Florida Supreme Court says so. I didn't issue this. The Supreme Court did. Now, let's talk about the Supreme Court's order. Now, remember, Supreme Court has what's referred to as discretionary jurisdiction, meaning they pick and choose which cases they want to enter an opinion on, whether it's a dismissal, whether it is an affirm, whether it is a overturn. I mean, whatever, thing they're going to throw at it. So when I filed this, and of course I've shown the brief, they could have just said, "Get out of here, kid, you bother me. We're not even going to hear it." They didn't do that. Okay. They actually took the case and issued an opinion, okay, citing no jurisdiction, clarifying that the appellate court, hey, we know what Mr. Howell is trying to do. There's a federal jurisdiction, a protection that we don't have here in the state of Florida. You need to clarify that. That's your job. Okay. So you see what I'm saying? The appellate court in the 5th district here is kind of feeling a little boxed in right now. And knowing and understanding that obviously I've been doing this a while, so I'm pretty good at it. And I'm showing everything. I'm, again, capable of doing every damn thing I say I'm capable of. one of the reasons people like John and myself and various others, that's why we have those licenses that are, in oaths of office, this stuff, all the stuff on the top shelf here. It's the reason that stuff is even there and it exists is because, well, we know and understand the complexities of what the fiduciary duty is, and we take that very seriously. So, in context of my corporation, people always ask me, what was my primary job function and what was the one thing I used to focus on? And they would look at me like I had 5 heads when I would say the customer. And they could never wrap their head around that. Well, you don't mean the company or anything? Well, wait a minute. The company doesn't exist. Your job doesn't exist without the customer. Never forget that. Never lose sight of that. And it makes them think a little bit. So when I went into the court and said, hey, wait a minute, you've got this actor, okay, this Florida Department of Revenue acting in a fiduciary claiming a capacity over or on behalf of, whether she pissed me off or whether she didn't, you're not performing your fiduciary duty under the law because you're not disclosing to her everything that you're doing to her. And here's how I know that. And it's obviously that's in the paperwork. So that's part of that compartmentalized audit that I talk about a lot. So again, that is where I apply this legal principle here, meaning to remove a guardian, because they've claimed somebody has had to have claimed some form of guardianship over her and or the kids in order to be able to claim that they can act on their behalf. Again, as a licensed professional, I know this. So part of the writ, which was to remove a guardian, okay, and that's where it comes from in law, the legalese principle, and there's where you can verify it on page 518 of the Black's Law 11th edition. So to answer many of your questions, yes, I have pretty much got almost all the way through the Black's Law 11th edition, which is probably scary to most of you. But anyway, again, I'm sure many of you have read it by now, so I won't, go all the way down through it. But, simple explanation, this is who I am, me, my business, acting as a defense contractor, loss prevention, come before the body. Okay, here it is right here. The body, sui juris, not before a court. Remember, you're going before this Office of County Commissioners, which is referred to as a body politic. So when you refer to it as this body, and then of course you're standing, that's the reason that you need to do this. You need to do it properly and clearly and those types of things. So as the sole arbiter of the law in the form of this writ citing lack of subject matter jurisdiction, see the remonstrance, the appellate mandate and standing in the Supreme Court's order citing this case. So that is further clarification as to why there's no subject matter jurisdiction here. And what we're here to discuss is previous trespasses against plaintiff to correct the multiple emoluments violations, errors, and trespasses committed within the emoluments, there's that word, of Marion County, Florida. Paid receipts attached. And what is, again, me and my maxims of law, what is proved by the record ought not be denied, right? So this is where you want to apply a legal principle or maxim of law to something as simple as a paid receipt that you've attached. That's why I said, do they really want to play Monopoly Corporation with somebody who's 10 times better at this game than they'll ever be? I don't even comprehend it myself. It just doesn't, of course I have a problem with stupidity, so that's probably just my fault. So anyway, here's the definition of the word. Okay. I took the legal principle and moved it down because I wanted to, of course, remember, I'm not talking to a judge now. I'm talking to my representative. So my representative is used to seeing things customarily in the dictionary the way you and I are. I didn't, of course, I still have applied this same legal principle, okay, to the word. I just did it a little differently, which would be more consistent with, depending on, like I said, knowing the person to whom you're speaking and learning how to properly address that particular body or person and why. So because I've claimed sui juris, and this is where I may piss some people off, and I really don't care. Not pro se is alleged in this fraudulent Sharia law sham process by this hearing officer who, as evidenced in the record, continually attempted to reduce this plaintiff's lawful standing in society through his odious claims. And as far as I'm concerned, this one is probably one of the most of the odious, right? He's meaning, it comes from Latin odium, which basically means shit made up, or now let me take that back. Odium is like disgusting, distasteful, that type of thing. So, and of course, me being me, too much subtlety in law is condemned. So you want subtle, go talk to somebody else, because you're not going to get that out of loss prevention. I can promise you that. I'm going to tell you the way it is, whether you like it or whether you don't. So he may have the rest of these judges fooled with his shit made up, or may have something on them, keeping them from performing their fiduciary duty to the Constitution. But make no mistake about it, I see right through him for whom and what he is, as well as where he stands in the fifth pillar of Sharia law. And of course, an unjust law is not a law. Why? Because that jurisdiction, that law, is tyrannical, according to the Declaration of Independence, and definitely not Republican in character or form, as it is consistent of 5 pillars, not 3. So, like him, I've spent my life studying my enemies, so I know one when I see one. If he is not shaking in his Sharia shoes yet, he will be when I see him hang in the town square for treason, according to the letter of the law. And there's the law right there. Title 18, USC, subsection 2381. As the body politic, my representative, she can certainly verify that. The crime of treason exceeds all other crimes in punishment. So in other words, I don't give a damn what's happened. At this point in time, we're not doing anything until we address this treason first. Period. End of discussion. So, of course, I date things. I have a problem with people who don't. And I have a problem with bodies of government that refuse to do this. And I damn sure have a problem with law offices that refuse to put a date on stuff. Nothing I cannot stand more than a vague document. As far as I'm concerned, if it doesn't have a date on it, it's void for vagueness. And one of those malicious designs that must be thwarted as far as I'm concerned. So you've read this before, my memorandum of legal authority. Again, going back through, this is more of a history, okay, that establishes, pretty much the subsequent, short version of a corporate history, that type of a thing, including how we've established this jurisdiction. So we're talking about civil rights. And the case where we got this has just been dropped in. Of course, I did share that. And as a matter of fact, that one, that one is actually still up on the screen here. So I'll share that in just a minute. But there's the receipts. There's the practitioner's affidavit. Let's talk about an affidavit, just the word. One of the main reasons why an affidavit is important. Who are you? Can I verify this? How, where, and why? And Dave, can you mute yourself there, brother? Damn it. All right. All right. Sorry about that. So anyway, we are, yeah, if you're going to come in, please by all means come in, but do me a favor and don't start your audio while we're sharing. Let me see here. Okay. So back to the document. And one of the reasons that, again, application of a case, why would I apply this particular case right under my license? Because I know damn well what the bar is thinking they're going to try to do. They're going to try to use against me what I intend on beating them to death with, which is the unauthorized practice of law. It's shit made up, because that law that they're practicing is not Republican in character or form. See, again, let's discussing, are we impeaching the law? Are we impeaching the fact? Are we impeaching the actor? Some combination of the all of the above? Who knows? So, because I'm impeaching the actor who is practicing and attempting to enforce this unlawful title or law, whatever you want to call it, that is where, as I've claimed it, as an unauthorized practice of law, according to the Florida statute 454.23. You can verify that if you want. And this is the Supreme Court's ruling where there can be no sanction or penalty imposed on one because of this exercise of constitutional rights. Well, I've asserted a constitutional right, and many of them in my remonstrance. So if they wanted to try to come after me, they wouldn't have a snowball's chance in hell. I'd beat them to death with that. Again, I would imply res excipiendo fit actor, as I have done. Let me just share that real fast, because I think this will clarify that for you. Right here, res excipiendo fit actor, which is the defendant by plea or exception becomes plaintiff. So looking at the unlawful orders, these false documents, this deceit, this shit made up, for lack of a better expression, where these actors purport themselves as the plaintiff and me as the respondent. Well, the appellate court said, wrong answer. Government is not a person. Government cannot bring an action or cannot haul a person into court without proof of a crime. Remember, burden of proof is on the moving party. So I came out and proved that their law that they're practicing is not Republican in character or form, and I did it through due process, which is, let me yank that little rascal up here real fast, because I think that's going to be pretty important when we're talking about in context of the claim and exercise of a constitutional right, as I just showed it in that case. So in my remonstrance, under the petition of remonstrance, under joint rules, remember, House and Senate, I'm saying, bring all your happy asses in here. Sit down. Wait for instructions. Here's the Florida Constitution, Article 1. You are the Article 1 branch. Here are the sections that we're going to discuss pursuant to these Florida statutes. Unauthorized practice of law and standing my ground. You got a problem with that? Let's go to work. So again, this is the reason why, how I've properly claimed and exercised the right through lawful, peaceful assembly, which means preparing your document. Okay. It's just hilarious that you're starting to see my language coming out all over the mainstream media. If that wasn't your first clue that they're paying attention, you're not listening. So, again, where I apply my fiduciary credential is where? In the Article 1 branch, because that's where I got this credential, was from the Article 1 branch. Doesn't have a damn thing to do with the court. So again, I already know what the bar is trying to claim, for example, what domestic violence is. Well, when you read the true context of the Constitution, that means attempting to overthrow the government by invasion or insurrection or whatever. Excuse me, which is why I jokingly said, okay, who stepped on the Lego? And, you know, got half the people laughed, which were actually not bar members, and the other ones didn't, were the bar members, because they knew exactly what I just did right there. I made them look like the dumbasses that they are. So, you know, it all depends on what you say, how you say it, in context. Okay. Again, here's something they can verify. Remember the book, volume 2, had that with me. And so again, when I showed this in context to, pardon me, the body politic, right? The Office of County Commissioners, there's my representative. Okay. She was able to verify that because, number one, I had the book with me. I also had the Mason's book with me, which she had never seen. Got a problem there. So, more on that as we go down the process. And, yeah, anyway, so get back to another question I answered earlier this afternoon. Where are we with the emoluments clause? Because what we know now is, well, the left cannot use it as a weapon against the president. They don't have the legal standing. But the word in the clause still exists in the Constitution. So that means we still have work to do. Now, that said, remember what I said about not putting a date on things. This is one of the main reasons why you do this. When you want to go back and you want to verify something, if you don't have a date on it, you can't prove when it was sent, when it was filed, or how the process was executed. Okay. So here, there's the receipt where you can go through and run that little tracking number right there if you want to. I don't know if it'll still be in the system or not. And verify that little rascal did go to the clerk of the Supreme Court of the United States on First Street, Northeast Washington, D.C. And in context, what is this? This was a notice of process. Okay. This was served November 20th, 2018, right around the same time I was litigating in the appellate court. It was literally right after I got the standing mandate. The standing mandate came out, I believe it was September 18th. Let me double check. Yes, September 18th. So that would be the reason why I took that mandate in standing and prepared the document. And yeah, there it is. So, and informed through notice of process. Remember, I'm a licensed professional. I'm not there to ask them anything. I'm there to inform them. This is what's going on. Again, you want to enter an opinion? Enter an opinion. And here's where I say that. This notice is to hereby inform the court of the pending applications of due process served upon and potential litigations in 3 congressional general assemblies, Ohio, Florida, and Washington, D.C. Okay. Pursuant to the attached mandate, here it is, page 3, issued by the 5th Judicial Court of Florida, citing my office with equal standing, and the directive from the United States Justice Department, which, remember that one on the prohibition on the use of guidance documents, that was in there. I will further continue actions as required by law to quash any further assaults upon either my person or my business, moving forward to expose the pyramid schemes of entitlements, which are unlawful emoluments, as I am confident the court will also recognize in light of recent events. Should the justices wish to enter an opinion on this matter, I would welcome any insights from their perspectives moving forward. I didn't tell them to kick rocks. I said, you guys want to enter an opinion? Go right ahead. I don't have a problem with that. You have a job to do. I have a job to do. We're going to do it. So at this time, I would also like to extend my congratulations to Justice Brett Kavanaugh, as well as express my deepest sympathies for him and his family for being forced to endure such a horrific process during his confirmation hearings. It has been close to 10 years and counting for me personally in dealing with such false allegations in my case. That's kind of my way of saying, welcome to my world, damn it. Right? So, again, said what it needed to say. You can't see it, but I had respectfully submitted, and all of those other things that I normally put down here at the bottom left of the closing of the letter of the document. But anyway, it's on my letterhead. It's official. Okay. That's due process of law. So, in other words, we don't have to go in there and say, hey, can I do this here? You say, no, I'm here to just inform you. I'm the master. You're the servant. I'm here to claim that standing in law. I'm not asking you. I'm telling you. So that's the difference of when you serve notice of process versus asking them a question. So, again, I found for lack of a better expression, a clever way to do both. I informed them of the process and said, you want to enter an opinion? No problem. So I didn't tell them, it wasn't, you heard what I said. I wasn't mean or condescending or disparaging to the judiciary in any way. I even said, dude, Kavanaugh, dude, that sucks, man. Kind of been there, done that though. So, kind of, hello, McFly, you might want to look into this a little bit further. So again, let's go back to the, whoops, stop sharing that. And I'm going to switch up here a little bit to that. So you guys should be able to see better on what's on the board behind me. I kind of went over this once or twice on the, on various live feeds. And one of the reasons I put it up on the show tonight was because I wanted to clarify how I recognize private sector emoluments. Now, within government, those are referred to as they have three elements: advantages, profits, and gains. Okay. Now, the private sector, those three things are market, margin, and capital. Okay. So that's how I was able to recognize them, see them, right? Absorb it and apply them in a three-pillared republic. Because remember, I think Kirk says this the best, the Constitution is the process for limiting government. So, for lack of a better expression, it's our way of going in and telling government, you're the one who can't do that. Don't you dare tell me I can't do something. I'm here to tell you that you can't do that. So again, just because of circumstances being what they are and the fact that I even have to sit here on the show and go over these things with you is indicative that, chances are we have a problem that's probably pretty damn close to what many of us are saying. And that Republican character or form, Article 1, legislative. Article 2 executive, Article 3 judicial. So again, I hope that kind of breaks that down a little bit better for you guys. So I'm going to check in on some of the comments tonight and see exactly what we missed, because let's see, I want to make sure I don't do, yeah. That's a good question. Katrina just asked the question. So would we still keep the top of to look more like the court record or more like the letter? That's a very good point. And boy, am I glad you brought that up. Now, let's go back and let's look at the other two. Let's look at the letter. And the letter is right here. Remember, what is a letter? A letter is a form of, like here, notice of process. You're informing them of something. Okay. Let's see here. Service of process, that's required. Okay. So that's the reason that we do a letter in context when we're informing them that we're actually about to take an action. So now in context of the writ, remember, this is where we apply our knowledge to things that we've learned. And you are now claiming, because again, I've already filed my petition of remonstrance, so that's in there and done. So moving forward, okay, based on what we've already learned in the case, I am now in this local legislator. So is this a form of another potential remonstrance? Well, yes and no. Yes, I'm bringing my remonstrance to this local body politic. Okay. But, remember, in for Marion County, Florida. So this is just specifically for Marion County. And knowing that Marion County is larger than the state of Rhode Island, we've got some ground to cover. So, one of the reasons why I address this more like a court document was because when you're talking about pleadings in practice, okay, this is an actual writ. So this could be construed as a legal document. So because it could be construed as a legal document, citing an appellate judicial mandate and a state Supreme Court order, it's more appropriate, more justified to prepare the document in more of a legal style format. Again, one of the reasons why I did the writ of deceit in all caps, because I want to make sure that my representative, Kathy, understands that this is more the title of the document. And these three here are legalese or legal principles, which I clarify further down here in the document. So when I talk about the accusus, meaning from whom, that is, and the reason I highlighted it is this person with whom I have an issue. Who is this person? Right? What is it? Why is I have a problem with this person's legal position, because that emolument doesn't exist in our three-pillared republic, period. So you want to verify that, Kathy? You can go to Black's Law 11th edition. If you don't have one, just let me know. I'll bring mine. So, of course, that's just me speaking off the top of my head. But point is it's where you can go verify it. And it's one of the reasons I quoted the 11th in this is because it is the most recent edition. So knowing and understanding that the bar members are going to come out and say, well, there's potentially something new that could be blah, blah, blah. Well, the current legal dictionary, the one that was just released, that is the current you know, the actual current legal thinking. And I don't know if I just lost you guys or not. So let's see here. Didn't plug in my other computer the way I was supposed to. That's okay. It'll be boot back up in here in just a second. It's decent that way. So here's the 11th edition. Okay. Been through that. As you can see, I've already started. I've made some pretty decent notes in there already. But, you know, again, they want to talk about where we come from, you know, in law, that type of thing. It's a, you know, or where the document, where can I go verify this thing, right? If I want to go look up this writ of deceit, is this something real? Okay. I think it was Jack was asking earlier about a different form of a writ, which I have heard in context would have been referred to as more of a writ of quo warranto. And, you know, we already know how they feel about writs of quo warranto. So, yeah, I hope that answers Katrina's question a little bit. While this is booting, I'm going to answer a couple more here. Yeah, you can add the date to every page, but it's more consistent to just add page numbers and put the date wherever you sign your name. So I don't know if anybody is aware of that or not, but it is customary to, you know, sign and date. So sign date, sign date, sign date. Unless you're doing like a one-page letter, like I showed, date up in the upper right corner, name and signature at the bottom left or right, doesn't matter. So, yeah, Ken, I'm here in Marion to run a billboard campaign. Sweet. You know who else was talking about that? Ken was John Gentry. We were horsing around with that on one of the shows one night, and he's like, you know, you guys can either do your job or we're going to come out and we're going to beat you to death with billboards. So, which I thought was pretty hilarious. And so, yep, that's right. That's actually redneck, Robert, you know, hillbilly, redneck, you know. So, let's see here. Oh, in the affidavit is your statement. Okay. This is, again, and I'll bring that back up as soon as the computer comes back up online here. Me as a practitioner, you know, holding this license, my affidavit is going to look different than yours because for a couple of reasons. Number one, I have this oath of office as a notary, so I know my fiduciary duty in that capacity is to the truth, because that's one of the reasons why one of my duties as a notary is to administer an oath. You see what I'm saying? So as far as what the oath is, where it comes from and why, that's in the notary treaty. So you don't have to tell me about the oath of office. I've probably forgotten more about the oath of office since reading the treaty than half of these jackwagons will ever know. All they know is they just put their hand on the book and said, I swear to blah, blah, blah. Well, I swear every damn day too, but that doesn't mean that I'm doing the job. So, you know, again, that's why I say, so as far as the affidavit goes, the affidavit as a practitioner is what I'm asserting is that everything in the document, okay, much in the same way the bar does it, which is when they register their bar card, that's technically speaking, they're registering that every document that they file is true and correct. Well, the problem with that is when we can definitively show that 99.9% of what they file is SMU, for lack of a better expression, This is one of the reasons why we run into these problems. And unfortunately, it backs the court into the corner of, oh crap. You mean to tell me that, we're going to end up having a potential problem here because we've got a bad actor attorney? Well, that could potentially screw up the court. And how many other cases is this jackwagon lied about? You see what I'm saying? So don't think they don't know it. I mean, the good actors know it. The bad actors are doing it on purpose, right? Literally forcing a good actor judge into that corners, knowing that, well, if I overturn this one, there's a potential mega shitstorm of real bad actors that could exploit that. So again, when knowing and having a licensed, a comprehensive understanding of due process and what it takes to build in a safety mechanism, being able to prove a negative literally is probably one of the best, highest safety mechanisms to protect the integrity of the criminal process as the lawful criminal process was practiced. Because we also know that with this transition from due process of law and American jurisprudence into this Sharia shit made up, they have literally taken and literally molded, created this globulated clusterfuck of reasonable hearsay. Reading doesn't mean reading. Need I go on? Right. And, this is us just going in and saying to the courts, dude, don't think you're the only one who's suffering this problem. So whatever fictional version of reality they think they think you're living in, or somebody has you convinced you're living in, that shit made up, dude. It is what it is. Hate to be the bearer of bad news. And good, computer's coming up here again, so I should be able to get this bad boy back up and running here. There we go. Now, whoops. Okay. Let me pull up that file because that was pretty important. Sorry about the screw up on the thing here tonight with the computer going down. Let's see, 20 rolling billboards. Yeah, Ken's here in Marion County with me. I got some stuff I got to get done here, Ken, real quick. I am going to be in and out of Marion County between Marion and probably Leon County, which is Tallahassee. And because of what I'm about to share here with Nate's case, I'll probably be in DC, which I'm going to show you guys. And Darren, dude, welcome back to the world of the living, man. Much love, brother. How you doing?
Back from debtor's prison.
I'm telling you, dirty bastards.
Working on trying to do something against them again.
Well, you came to the right place, man, because we are we are going after.
To do.
Yeah, you betcha. You betcha. That's all right. We'll get them. We'll get them. Let's see. I think is it this one? So I think this was the state. This was the state remonstrance for the Texas case. So I want to kind of go over this real fast. So, let's see. Maria asked a question. Can I do something similar without being licensed? Credentials are credentials. Any professional credential has a specific purpose. Like I was just talking about, the notary treaty, or being a notary, there are inherent duties that come with being a notary, one of which is administering oaths of office. Another one is verification that the person signing a document is actually the person signing the document. And we actually have to administer the oath that says that you are signing this document of your own free will. You're not under coercion or, duress or anything like that. So if your notary doesn't ask you that, tell them they might want to consider rereading their oath of office in their treaty because they're not doing it right. So, especially when you're talking about a legal document. Now, if you're talking about just notarizing title to a car, okay, yeah, John Jones, that's you. Okay, yeah, that's your ugly mug. Okay, cool, that's you. Sign there, and you're done. So, again, depending on the document. So, in context here, that's actually a very good question. So, thank you for asking that, Maria. Yeah, Ken's working on working billboards, and billboards are actually not a bad idea because, man, I'll tell you what, Ken, what we might want to consider, bro. We're literally right on the Route 75 corridor. I can't believe I didn't think about this. Why don't we take up one of those big ass billboards, one on the south side going north side and one on the going south side? Where they have all the, all the signs for the truck stops and all that other garbage. I guarantee you, one of them suckers got to be open at some point in time. It's just my brain going crazy. Let's see here. Yeah. Yeah, Chad, you got that right. Fuck how they feel. Let's see. Oh, Dana, perfect. So and understand the as a notary, I'm sure you've read your treaty, you've got your stamp. I don't know if you have your embosser or your state seal or how much of your kit you actually purchased, but I purchased the whole damn thing. And as a matter of fact, boy, am I glad you brought that up, because there are actually some documents, if you actually really want to do this as a notary. What in the hell? There we go. There are let's see. There's this one. And I'm going to share these with you. I don't know what state your notary is in. Okay. Let me do this real fast, because Dana brings up an interesting point as a notary. Let's see here. There we go. Now, you're talking about wanting to, we know we're talking about oaths of office. You hear this a lot. Well, one of the Florida short forms is an individual acknowledgement. Okay. So the foregoing instrument was acknowledged. Well, what's the instrument? Okay. You go down through here and you fill this thing out. And this is where you would put the type of document, oath of office, or bank statement, some form or fashion to acknowledge that the other side did comply with a subpoena ducis tecum, which is a specific subpoena to produce a specific document or, set of documents, whatever. And the document date, again, there we go again. I'm anal about dates, and this is one of the reasons why. Now, number of pages, why we put page numbers on things. Okay. So if you're like, let me just stop this real quick, because here's a good example of that. John, if you're watching this, you might want to pay attention to this. That form, when they took your remonstrance and changed your remonstrance from what was it, 70 pages, I think you think is what we said it was, something like that, to like 13 pages. Well, you could file an acknowledgement that you do acknowledge that they filed a 13-page document, but to correct the record, here is my, as evidenced in the congressional docket, here's the actual 70-page document, right? So this, you could clearly establish that there was hanky-panky or funny business went on. So I wanted to, that's actually a good, I wanted to answer that in context, because that was kind of a double duty answer in context of some things that we're all working on here as we go along. So the other one is a Florida Jurat form. And this is basically exactly what it says. Go to the Florida statutes 117.005 to learn all of the uses of a jurat. You know, again, type of document, document date, number of pages, and the signer other than the named above. Okay, so if the document came from a department and was presented by John Jones, so John Jones would sign as the person presenting the document. I hope that makes sense. And name of the person swearing or affirming, that would be John Jones. Signature of the notary, that would be yours truly. And of course, you know, where you place your notary stamp right above here. And if you have your seal, okay, you can seal in your embosser, your seal. You can emboss the signatures so they cannot be tampered with, which is what I do in context when I fill out a jurat form. So, again, these are tools you can get for your notary toolbox, you know, to put in your notary toolbox that will allow you to perform your duties as a notary pursuant to your oath of office. Because I guarantee, like me, you've got one of those. So with that office comes specific privileges and duties known as emoluments. That's where those come from. That's the name of the word. So, you know, when we talk about what is an emolument, as Bill Barr said, it's a stipend attached to some office. Well, we've read what a stipend is. So that's why I said it's, you know, as we run down through some of these things, I'm what I'm hoping that you guys are starting to clarify a little bit better for yourselves is, you know, why some of these things work the way they do and some of them just don't. So, you know, it's just kind of the nature of this beast. And one of the methodologies of incorporating into the state, and let me pull up that design again, because I've been asked to clarify this, believe it or not, which I thought was strange because I thought I'd already clarified this more than once, but I think they were just, whether they understood or didn't understand it, I think they just wanted to know and make sure that I totally understood it, which they found out that I totally understand it because I built it. So clarifying that jurisdiction, 28 USC 1443, proving a negative. That's instituting a safety mechanism that protects the integrity of the judicial process, the criminal process, as we currently know American jurisprudence, the way due process of law is supposed to be practiced, not this Title IV Sharia shit made up. Again, my status, fiduciary status, my standing to present, right, as if I were administering an oath of office. So And of course, the judicial mandate, which further clarifies where my standing is in the matter as the plaintiff, which of course, let me pull that back up again, because going back to the clarification of why you construct your document as you should. Let's see, here we are. Okay. And the better you, and of course, like we say, the more the more you do this, the better you get at it. So, in the office of the county commissioners and for Marion County, right? This may have something to do with the court in a little while. It may not. This may just be an indictment. This may how this ends up, because that's a very good possibility in total context of what we're talking about, because I've already impeached the bad law. I've clarified my position and standing. We already basically decided that that is there's no jurisdiction. That's shit made up, and it would help if I'd share the right bloody document. Let's see here. That's the one I want. That's better. I actually did change the writ of supervisory control and did file that as part of this process, but it was just the same header. I just took the court's header off of it and put this header on it. So, and again, clarification, which body it's going to and why. Reference in the matter of, what is your position in this matter? Me, I'm the plaintiff as by appellate mandate. See the appellate court if anybody has a problem with that. I didn't write that, the appellate court did. So again, who it's addressed to, the person to whom it's being addressed in this case is my commissioner. Here's the case or matter number, who the respondent is, and why that claim and that position and standing is in error, as confirmed by the Florida Supreme Court. You have a problem with that? Go talk to the Florida Supreme Court. They're the ones who said that this jurisdiction is shit made up. They confirmed. Well, I alleged it. They confirmed it. So, that's why I say, as far as you can actually get them to do more for you by getting them to shut down the court case, because then nobody can come in and say, oh, I'm claiming and exercising separation of powers. No, you can't, because if we're not litigating, that means there is no case. So if there is no case, which takes me to the topic of temporary orders, the worst version of shit made up. That is one of the methods that the courts actors use to perpetuate litigation. Well, we're just going to say this for now, temporarily, and we'll look at it again in 6 months. What are you supposed to do in 6 months? I'm sorry, I'm not going to let any asshole uncle or whoever tell me what I can and cannot do in my republic, right? Again, claim and exercise of your right. So, you want to claim that this is a violation of separation of powers. This order, right, issuing this temporary set of circumstances, you can't issue a temporary set of circumstances. You can't be a little bit pregnant. You either are or you're not, right? Yeah. Properly exercising something somebody can comprehensively understand. Yeah. Well, one of the benefits of having women in politics is can you be a little bit pregnant? Hell no. Okay, then. See what I'm saying? It's a way to get them to be able to clarify it in their head, just as to what's the difference between hey, we're done here versus, hey, this is where this is shit. They're just trying to keep it up and perpetuate it. Well, what do we know about that? Perpetuities and monopolies are contrary to the genius of a free government. That's in the Texas Constitution as well as several other constitutions, which is one of the main reasons why I've still got Texas on the brain since I've been, doing as much as I've been doing with Nate's case, man. Oh my God. So, matter of fact, let me show you that real quick because I'm sure you guys have heard me talk about that before. This is from Texas Article 1, Section 3, as far as equal rights. All free men, when they form a social compact, have equal rights, and no man, family, or no man or set of men, right? Well, what's the bar? That's a set of men who has a monopoly standing over the court. I said, no, you can't. Why? Let's see. Article 1, Section 26, perpetuities and monopolies. What does that say? Perpetuities and monopolies are contrary to the genius of a free government. And shall never be allowed, nor shall the law of primogeniture or entailments ever be enforced in this state. I think it's safe to say the bar actors in this particular case, as we've clearly explained it, have pretty much pissed all over those two sections of Article 1 of the Texas Constitution. And again, to know a thing and to be bound to know it are regarded in law as equivalent. The Article 1 branch is bound to know what the Constitution says. You see what I'm saying? So we talk about where the hell did these bad emoluments come from? You can go down the rabbit holes of conspiracy theories all day long if you want to. Let me bring that back up again because I think this is the document where we didn't just come out here and make the claim. We came out here and confirmed it, right? Well, how can you claim that constitutional provisions were provided for in this 446th Judicial District Court of Ector County when the word Constitution doesn't even appear in the order? Texas will formulate an appropriate strategy and method to effectuate the intent of the 446th Judicial District Court's designation. If that isn't shit made up, I don't know what is. I mean, that is by far the worst version of shit made up I think I have ever read since I've started this. This is the reason we got 1,250 cases dismissed in one day because of word salad, just like that. And it's knowing how to go in there and impeach it. Because when we're talking about impeachment, people think, oh, I'm going to impeach the actor. I'm going to take the actor and string him up. Well, you can impeach the document, the document's validity, the document's legality, as long as you know and understand comprehensively what it is you're impeaching and why. So in the document, and I believe that would have been, again, because we're talking about the principles of group decision making. When we go back up to the remonstrance, let me pull open the bookmarks here. Those principles of group decision making from the Mason's Procedural Manual, 2010 edition. Texas uses this too. Well, what do we know about those 10 principles? And we can verify those. Here it is, number 10. To be valid, any action or decision of a body must not violate any applicable law or constitutional provision. There it is, right there. You don't need rocket science to verify that. You said, you see what I'm saying? This was how we impeached the defective emolument, which was formerly known as the 446th Judicial District Court. So That's why I say, when I think about Nate's case, Nate's case is actually, was not just my first case, but it's the one I've kind of dumped most of who I am and what I do into it. So, I have take if there is 9 guns of hell from E-Clause, the actors in the Texas case are on the receiving end of all 9 guns of all 9 of those guns. You can trust and believe. Just trust me on this. So, that's why I say it's to be able to come out and share the stuff with you guys and teach how to do this and do it properly. This is one of the reasons why we're going to start to see a whole lot of things change really quickly here, including finally answering questions like, what the hell does this word emoluments mean in context of the law? Because again, as I've clarified it in the document, let me show you that legal principle, that maxim that I've chosen. You know me, I love my maxims of law right there. In order to rightly comprehend a thing, it is necessary to first inquire into the names, for a right knowledge of things depends on their names. How do you argue that? How could anybody in a position of emolument, okay, that word, how can they argue the reasonable nature of, if reason in law is the perfect equity, how can you argue that that is anything less than reasonable as a legal principle to apply to that word for the first time in our nation's history? That's why I said, I like to quote Albert Einstein because his methodology it describes a lot of the way my brain works. And when he said that education is more than just the learning of facts, it's the training of the mind to think. So, you need to not just apply your facts, your knowledge, your history, but, learn how to take those things and literally mold them into something that is comprehensive. I look at it this way. If I'm having these same questions, I'm not the only one. So, to have the same problems as the president of the United States, basically false allegations, hell, my life could be a hell of a lot worse. I already know how I'm dealing with that. Working on that now. It's getting rid of the actors. The dumb shit who thinks his shit doesn't stink is really the bully. That's the that's the bastard who's gonna end up at the end of a noose. And he did it to himself. He did all the work. So don't blame me. Don't blame you guys. Don't blame anybody else but yourself, numbnuts. So let's see. Brenda. What does Brenda say? Brenda is going to give the public servants questionnaires to the agency players tomorrow before mediation. Ooh, very good. Very, very, very good. That's actually a very good question. Or that's a good point. The word agency. Okay. Well, let's break out the big book and see what does the big book say about agency? Because in commerce, agency practice is the ability to write a contract that meets all the required elements of a contract. So let me go back into the big book here and let's clarify. There's agent and agency, just as a general definition. Mind you, I'm not really going at this from anything specific. I just want to just go into here we go. Just a general definition of agency in context. So we're looking at, let me see what here, a definition. Agency, a relationship that arises when one person, a principal, that would be the person who's paying for the contract, and sorry, but no, I need to mute that. There we are. And so, okay, sorry about that. So let's see here. A relationship that arises when one person, a principal, that would be you, the payer, manifest assent to another, the agent, that would be me, that the agent will act on the principal's behalf, subject to the principal's control, and the agent manifests assent or otherwise consents to do so. An agent's actions have legal consequences for the principal when the agent acts within the scope of the agent's actual authority or with apparent authority, or the principal later ratifies the agent's action. So, that's pretty close to the fiduciary duty in context. So, when you're talking about, I mean, that's some pretty serious language. Let me clarify that again. A relationship that arises when one person, the principal, that would be the payor, manifests or assents to another, an agent, that would be me or whoever, the payee, or in context, the attorney who you pay to perform this service they call representation, which they never do. That the agent will act on the principal's behalf, subject to the principal's control. I don't know anybody who's ever paid an attorney who was ever anything that expected anything other than that. If I'm paying somebody to do something, I'm the boss. Same thing with you guys. How many times have you paid these attorneys to do something and they say, "Oh, I can't make those arguments"? You took my money. You're going to make those damn arguments. And of course, they give you, that passive aggressive line of bullshit. So, this is what I'm saying. Being able to properly claim and exercise. Look, I know what agency is. I have a license for that. It's in commerce. So when you're using the commerce clause to trespass the law, you're actually the one guilty of unauthorized practice of law, you jackwagon, because you just stepped into my commerce clause unlawfully. I'm the one properly licensed to be here, not you, attorney person. Kick rocks. So you see the conundrum that the court now faces, because I've come out and I have definitively claimed and exercised my proper agency relationship in due process as it relates to due process and commerce and contracts and all of that other fun stuff that we talk about here. And so the whole point about this is one of the main things I want to be able to help you guys know and understand is when you're preparing your document, you have to really sit down and you have to think, right? And let me go back over and just run through this one last time, because this is so important. Because right out of the box, you need to know the body or person or to whom you're speaking, or to what you're speaking. Okay. Are you speaking to the court? You speaking to the legislature? Okay. to, where, where are you? The first three rules of real estate: location, location, location. The person to whom the document is addressed. Okay. That's pretty important in context of what it is you're asking them to do and how and why. Whether they know and understand the legal principles or legalese of Latin being the thing that moves the court or not is not so much relevant as the fact that we understand it and clearly can properly articulate it. More flavors than in ways than than they'll ever understand. So again, now in reference to in re, the matter of, okay, this is where it begets, this is where it gets now where we talk about your standing in law. Okay. We already know what the other side is claiming. They're claiming that they have this power over you in that you're just this pro se litigant, disgruntled pro se litigant. Sorry, I had to clarify that. When everything they're alleging has been shit made up from the word go. So you're going in there and you are claiming you're standing in law. Remember, sui juris or in propria persona or some combination thereof, depending on how you're going to do it. Who you are, your position in the process. I took the time to mandate where through the appellate court, through an actual court of law, not a court of equity, where I'm standing. And it would appear by in case style, as I said, me versus them, because I'm the person with the political power, with all the power, who can actually make an argument. And they are obviously not capable of making an argument. So damn it. Now, the person, the entity, the quote unquote government, son of a bitch, there, this Department of Revenue, the department is nothing more than a piece of paper. Okay, government is a piece of paper. It's shit made up. How many times have we got to go over that? So how can they act on behalf of my ex or anybody else for that matter? Because according to the Supreme Court, who claims there's no jurisdiction, that means that relationship, that agency, okay, doesn't exist. That's the reason I wanted to go over that agency. So they cannot claim an agency that cannot exist by ruling of the Florida State Supreme Court. That's the reason it is in error. So I hope that clarifies that a little bit better for you guys, and knowing and understanding that even as licensed professionals, we're having the same problem. The difference is, knowing and understanding that we know how to combat it and fight it. I don't have a problem coming out and teaching you guys the benefits of all of my years of experience, because literally by helping you, it helps me help you help the kids. And again, like I said earlier in the video, in the context of my work, who is the primary person or persons of importance here? That's the kids. Because in the document, I've clearly stated it. Priority 1. Go look at the certificate of interested persons where I put the kids' names in there. That says priority 1. So in other words, if we're not talking about the kids, we ain't talking. You can take your other emolument shit made up, your fictional process, and kick rocks. I know what you're trying to do, and I know how and why you're trying to do it. What they don't like is the fact that I caught them with their hand in a cookie jar. The kind of the wait till your father gets home joke. Well, father came home and caught him with the hand in a cookie jar. Now they're screwed. So, following up on the emoluments clause thing, just close this out real quick. We know and understand that the Democrats cannot use the emoluments clause as a weapon against the president of the United States. By unanimous decision, the 4th District Court of Appeals held that there's no legal standing, hence the fake witch hunt. Okay, so they've changed their story 3 or 4 different times throughout this thing. First of all, they were pissed off because he was a businessman. Then they went to this witch hunt with these foreign actors, right? This Russia. And, you know, then they that's why I said they've teetered. They've back and forth between the Russians and the fact that Trump is a businessman. Well, they can't marry those two things together, not lawfully anyway. So because they can't marry those two things together in a comprehensive manner, right? Apply some legal principle, some finding of fact or conclusion of law that would confirm their allegation. It's nothing more than shit made up. And it's only come out that this document that they used to get the warrant to begin with was defective. And it already has been impeached multiple times. So they had lost this case before they even entered the appellate court, which really surprised me why they even attempted it. But nevertheless, they attempted it. So anyway, fast forward to where we are now. We know why we got the unanimous decision to dismiss the case against the president, because there was no freaking legal standing, period. End of discussion. But it doesn't change the fact that the language of the language is in the Constitution. I have presented a lawful petition, redress of grievances, to the Article 1 House that makes a whole hell of a lot more comprehensive sense in law, based on the fact it's my grievance is based on an action taken by Congress. You see what I'm saying? So in due process, yes, I informed everybody. I informed Trump. I informed Congress. I informed Trump. And as I showed earlier here in the beginning of this video, I informed the Supreme Court November 20th. It's been sitting there on their desk ever since. So, you know, Democrats or whoever is going to try to contemplate taking that case to the Supreme Court, I beat you to it. I'm already there, guys. I'm just there waiting on the desk for you. So you want to come and go toe to toe? Let's go to work. I'm ready. Let's do it. So, you know, hey, I don't have as far as bullies are concerned, I prefer a good stand-up fight to all this screwing around. Let's go to work. So, you know, but I promise you this much, what's going to end up happening is, by the time this is all said and done, it's going to come out that my assessment of Title IV and Obamacare and all that other horse shit being in 5 pillars, Sharia and character and form, is pretty goddamn indicative as far as the fact that we're being invaded. There's that domestic violence. You see how that fits the political argument, right? The whole thing fits in context. You're not going to tell me that. Let me pull the damn thing up again, because, you know, I get so tired of going over it, and we might as well be looking at it. Shit. There it is. So let's look at this little rascal. So let's impeach the document. Let's do that. Well, we know that domestic violence is a political argument. It's a process reserved for Congress, right? So how do we have court cases with, say, domestic violence on them? I have an issue with that. That was an issue taken by a court practicing law that was reserved for Congress. Can't do that either. Violation of separation of powers. So we got a multitude of problems here. The affidavit looks nothing that's in the case. I guarantee you has nothing to do with either myself or my kids attempting to perform some act of insurrection over the government. I guarantee you that language ain't in the affidavit. So that's why I said their whole case falls apart. Their whole argument falls apart right there. In context of the advantage, the fake jurisdiction the shit made up of Title IV, what is the shit made up? Title IV. That's it right there. That's the emolument scam. They claim those things as entitlements. Why? Oh, that's because they're that arrogant. That narcissistic, malignant narcissistic mentality that we deal with. Well, their worst mistake was teaching me how to fight malignant narcissism, because I can't stand it. I have a problem with it. And I'm way better at Monopoly than they are. Sorry, hate to be the bearer of bad news, but you're treading in the wrong house if you think you're going to play Monopoly with me. So again, what does this thing guide? What does this thing run by? Right? What's its gasoline? What's its fuel? That would be these guidance policy documents. So okay, in the context of these guidance policy documents, what do we find? Statutes, codes, rules, and regulations. And of course, other such word salad. So in context of the process, this jurisdiction that is outside of our style and form of government, remember the Declaration of Independence, he has subjected us to a jurisdiction that is foreign to our form of government and unacknowledged by our laws. I don't acknowledge that. That's the reason there's no jurisdiction. It was law that has failed and is going to fail miserably. It actually, in my particular case, 3 years before I was married, it failed. So how are they claiming full faith and credit in something that they know was a fail? And the fact that I've brought it to their attention correctly only makes it that much worse. You see what I'm saying? This only shows the indicative nature of how arrogant, how negative within this negative nexus right here. Okay. That shows the negative conduct of the actor right there. That's the negative evidence. There's the negative actor, the negative conduct of the actor. And the court sees that as a positive one based on two fundamental principles of law. So in effect, yes, two wrongs do make a right. Harry, hate to be the bearer of bad news, but that's reality. Life ain't fair, folks. Just it is what it is. So, but this is how you combat that. Whether you assign it as the malicious designs of men, we know this is a malicious design of men as declared in the Declaration. It is a cursed construction that corrupts the text. Well, this is the cursed construction that corrupts the text. That's why I applied that legal maxim there. And of course, because our system of government is only 3 pillars, therefore the process has to have 3 pillars to it. What is illegal ought not be entered under the pretext of legality. That's the reason it is treason. So against our style and form of government. And I think there was one last thing I wanted to share in context of the Declaration here. Let me pull that up real fast. Here. Nope. Aha, here we are. So, pull that rascal up there. Share this. in my favorite historical document, the Declaration of Independence. There she is. From this line, this is, again, part of the preface of my judicial practitioner's report, or practitioner's judicial report. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design, there was the design, I just showed it to you, to reduce them under absolute despotism, it is their right, it is their duty, in my case, fiduciary duty, to throw off such government and provide new guards for their future security. I kind of did all of the above right there. I'm throwing off that government in the form of a Supreme Court order, right? There's no standing in law for that in my republic, period. And I have shown the design, that malicious design of men. There's the design. That design is designed to do what? Reduce them under absolute despotism. I think everybody who's watching this video tonight has experienced that emotion at some point in time, or you wouldn't be watching. So, I've accepted, as I've said, I've accepted that duty, that fiduciary duty, to throw off such government and to provide new guards for their future security. Well, let's see here. I have taken the liberty to give that new guard a name right there. Loss prevention. And there it is right there. There's my logo. There's my company logo. So, that's why I said anything they think they can do, anybody who's actually professional in doing what we do, we can do it a whole hell of a lot better, because we got skills that they'll never even comprehend. And again, knowing and understanding, nature abhors a vacuum. This is also the other conundrum. What does that do to bar members? Right? That's again, because the court has to, there's going to be a decision made here. Now, I'm advocating for them to have to incorporate into the state, just the same as any other agency actor, myself, John, a doctor, a hairdresser, anybody who performs a service or sells goods to the people has to incorporate into the state. This fourth pillar bullshit is just that. It's bullshit. You want to claim you're going to do this job, you're going to assume this fiduciary standing and duty, fine. But don't take somebody's money and then not do the fucking job, you jackwagon. I mean, let's just call that spade a spade. So, but I digress. I could bitch about that for hours and never get sick of it. But anyway, I think this is another Florida case. Let's see, Ray, I'm actually getting ready to run into a bunch of bunch of stuff in the legislature as well as Marion County. I'm going to be backing and forth in between Leon County and Marion County here pretty quick. So I don't know exactly how long that's going to take. So, I don't want to commit to something and not be able to, literally dump everything into it, because I actually have more than one Florida case here. Plus I might end up going to Idaho, depending on exactly how that case comes out. So, again, more to follow on that stuff. I know I've got stuff to do in Texas and Washington. Let's see. Do you use the word legal or lawful standing? Melissa, very good question. Legal or lawful? Very good question. What do we know about the difference? Legal standing is in terms of a contract. Lawful standing is where you're standing in law. So to answer your question, where you're going to speak in front of a body politic, that would be your lawful standing. So if you're claiming that the legal position is in question, let me share that real fast, because that's actually that's a very good question in context, which goes to the basic principles of the name of the document, writ of deceit. You're questioning the other person's legal standing or lawful standing. This is the principle that you use to do that. Okay. And there's the definition. Number 2, the person whose legal position is an issue, right? I have an issue, or you have an issue with this guardian ad litem, with this CPS worker, with this hearing officer. Show me in the Constitution where the hell that emolument exists in a Republican form of government. Kick rocks. Right? So, a way to apply, or to a principle to apply deceit, meaning of deceit, is this one right here in context, which is why it appears right here, right under the title. And of course, this guardian, this person who's claiming they have this standing, remove a guardian. That's the Latin designation for it. And that's the definition, to remove a guardian, or a writ to remove a guardian. So in the title of the document, I have asserted the title, obviously, and these 3 principles or practices, if you will, of actual lawful and American jurisprudence and lawful position and standing, pursuant to me being the plaintiff against this respondent. Okay. So you see what I'm saying? This is how you go in there and you just pound the snot out of them. You can't be afraid of the wind, So, you're claiming your lawful standing in the body politic. You're questioning their legal standing as, oh, I'm here to execute this contract. Well, your contract isn't lawful. So if it's not lawful, it sure as hell isn't legal. So that means your legal standing is also in jeopardy. Again, how you pull the rug out from under them, and why unanimously we got the answer of there's no standing in law for them to do this. They had no findings of facts. They had no conclusions of law. They had absolutely nothing with which to base their claim on. I mean, they literally had nothing against the president. Not a damn thing. They had less than nothing. And unfortunately for them, the only thing that we did learn is that a shit ton of them are guilty of the exact same shit they accused him of. Remember, res excipiendo fit actor. This isn't anywhere near done yet. So, I hope that answers that, because that's actually, Melissa, that was a damn good question. Yeah, bar society. I don't even think that is legal. I think, that's why I said it's shit made up, That's nothing more than a gym membership, private club. Well, go do your thing, private club. That's got nothing to do with law. Kick rocks. So, and you know what, to be honest with you, I think that's actually, it's not going to it's not going to solve every problem, but it is going to solve one major problem for the court. Anybody who practices, and I don't give a damn if you're a plaintiff, you're a respondent, you're going to have to prove your status, your standing, and your jurisdiction before you get a case number. Or if you do manage to get a case number, only to find out later on that your shit was made up, that's what the Shit Made Up Act is designed to do. One of its functions is to give the court the ability to expunge, right, clean the record, wipe the record clean, the slate clean of a bad case. Why should somebody be branded as being charged with something that was only confirmed to be shit made up anyway? Who designed that system? So, again, give them something. You want them to do something? Here's an idea. Let's do that. You hate bad cases? So do I. You don't have a trash can? Yeah, you do now. It's called the File 13 Act or Shit Made Up Act. I don't care, whatever you want to call it. So, I don't know, Daryl. We're just sitting here shooting the shit. We've been running our normal, about 2 hours. So let's see. People who could profit from it. Yeah, that's a good point. Yeah, well, the problem with that is if because they've profited from it, again, just because they profited from it in the beginning, that doesn't mean they get to keep it. So that's one of the reasons why we're able to go back through and state, okay, here's what they did. Here's how we know what they did was neither legal nor lawful. So here's why you're not only going to return my kids, but you're going to return everything else you stole. Plus you're going to pay me damages. And that process happens in the Article 1 branch, which has nothing to do with the damn court. So if you let them bully you into a court, expect to get beat up. So don't let them bully you into a court. Kirk, what are you doing, brother?
How you doing, bro?
Hey.
Howdy.
That's a nice hat, bro.
It was my dad's hat. My mom gave it to me yesterday.
Oh, yeah.
We're working out in the yard, getting all freaking sun beat burnt.
Right?
How y'all doing tonight?
Oh, we're just shooting the shit, going over this writ of deceit, and was going over, I don't know how much of the show did you catch? Probably.
I missed like the first 3 minutes of it. I was multitasking over here as in another private web deal.
Gotcha. So you saw the, in the county commissioner's office as opposed to in the court of and all of that shit made up. Okay. So
all about who the parties are, right?
Well, it's not about more than who the parties are. It's in which body, what office, what your location are you standing? All of your political powers in the legislature.
Did you say location?
Yeah. The first 3 rules of real estate: location, location, location.
the locus, jurisdiction, the land.
There it is, right?
Don't out on the water.
Swim, bitch. Oh.
Swim through them dirt clods.
Damn right. So yeah, we're just I don't know. You got anything you want to add to the to the subject, since you caught most of it? I'm sure there's probably something you could probably throw in there. But what we've done is today is we began the process of impeaching this bad actor who is practicing law that is not Republican in character or form.
Yeah.
So we literally today, on this day, we began the process of impeachment of this local actor. So that's why I said it's all about how you not just claiming and exercising it legally, lawfully, etc., but location. How do I know my standing is this? How can this body politic verify that? Right? So, and all of those things that we've discussed on Kirk's Law Corner. So,
yep, your status, standing, and jurisdiction.
There it is, right there. And I think
problem is your parents already declared your status for you, and you're lost out there on the high seas and the Holy See of Vatican. But I digress.
Well, hey, I said, well, you thought I was on a boat. Well, the boat sank, but turned into a submarine, bitch. And I can torpedo your ass from where I stand.
Get out your black powder.
What's that?
To get out your black powder.
Hell yeah. You got that right. So,
Yeah, it's all about asserting your rights, asserting the law, being the law sayer, right?
oh yeah, absolutely. Shit. Drop the mouse.
You got a lost mouse?
Yeah, the one mouse for this other computer here.
Where's your mouse trap?
Beat the snot out of him with this. Whack.
You guys have mice in Florida?
Yeah, actually, we do, believe it or not. Field mice. They're only about like that big. They're tiny little bastards.
Oh, wow.
Yeah, they don't get big at all. That's one of the things. I think some of the bugs are bigger than the freaking mice, which is pretty fucked up, to say the very least.
Yeah, you get some pretty strange bugs down there.
Right? So, let's see here. I was just going back through here, checking up some of the comments. Yeah. Signature and seal. What Myra, what do you want to know about the signature and seal? There's been a lot of talk about that. The seal specifically. What do you mean by the signature and seal? Can you clarify for that for me a little bit?
I wonder if she's talking about the judge's signature where it's supposed to be in writing, and then under that it's supposed to have the actual full name of the alleged judge and a court seal.
Let me pull up a couple of examples here and see if I'm understanding her correctly.
Talking about hats over here. Got this one. Got this one.
Oh, hang on.
We can do Swamp, Idaho. Of course, then we got my David Strait hat. We were on the road. He bought this one for me.
Well, since you're doing hats, here's mine. So,
Like that one.
hang on a minute. I got to switch. Drain this.
And of course, my daily wearer, good old Mount Rushmore. This is a really nice hat. This is actually a leather hat. It's leather. It's not cloth.
Really?
The whole thing is leather. All of it.
Damn. I'll be damned. Well, can't feel.
But for all intents and purposes, for tonight, bunch of rednecks out here in Idaho.
You betcha.
Keeps our ears from getting burnt and our faces from getting burnt.
In your
What's
neck,
happening, brother?
In your neck from getting red. So.
Yes, it does.
So that's where
You ever wonder why a lot of people wear hats like this? It's because they're out in the sun a lot.
That's right. That's where the name redneck come from. Somebody who doesn't know what kind of hat they're supposed to be wearing. So.
Yeah.
Let's see here. Did she clarify? Yeah, on court documents, the judge's signature is there, but no seal. Okay. So actually, I just did an example. I think it might have been even on was it this one? Yep. And I think if this is exactly what Myra was talking about, I believe this is because we were talking about this on the show last Friday. The difference between a pen signature and a stamp signature. And you see, here's two pen signatures. There's a pen signature. There's a pen signature. There's a stamp signature, or something other than a pen signature. And the line that's, you see how we've identified this. You're supposed to put the person's name in their job title for them to sign. All I see is a circuit judge and a stamp. So in context of this document, yes, I'm impeaching that as a lawful signature. And again, in the state of Florida, we have this pesky requirement known as, oh, wait a minute, this is Nate's. Let me see if I have mine here real fast. Petition of remonstrance, Florida remonstrance. Here we are. And I do believe it is in there. Affidavit, judicial mandate. Aha. Yeah, here it is. When we're talking about the seal in Florida, there's our state seal. Okay. And when we're talking about a judicial mandate, let me zoom in on this one because this is pretty big. This is the appellate seal. See the difference here? You can tell where she signed in ink, okay, as the clerk, and there is the seal, right? So you see kind of the difference there between the documents, between what this jerkface did here with this SMU, right? There's no, this person is just an administrative assistant. So there's no titled, other than administrative assistant, but because there's no authority there, that would be just as a witness or somebody performing a function. When you're talking about somebody with indicative authority, there has to be the name, what the authority is, where it comes from in law.
Yep.
And then the place for them to sign.
Official job title.
Yeah, that's not what this is. This is SMU. And
Nope.
oh yeah, what is missing? The seal, the court seal. So in context of Myra's question, I hope that answers that. This is in Chancery Court. The chancellor is also a member of the bar. Well, again, we know that, and that's the monopoly control they have over the court, which is, as far as I'm concerned, therein lies the problem. Are you going after the bar, bro? Because we know it's the bar that was infected with, let's see, the Democrats brought over these idiots from these fucking Muslim countries and said, yeah, let's teach them our law. That's like hooking your fucking car to the internet. What could possibly go wrong? Dumbass. I died.
Yeah, so you're still sharing?
Mm-hmm.
Oh, okay. I was gonna say here's my court state seal, right? Right there.
Mm-hmm. Oh, speak again. I screwed it up.
Oh, okay. Yeah, here's my court seal or state seal right there. But you rarely find any of these seals on these documents, and this goes back to what Traben was talking about in a private after show one of those nights ago, a couple of weeks ago now.
Or a score in 11,000 years ago.
Right, the ISO 9001 document templates, what they're supposed to look like.
Right.
What they're required to look like, to be lawful documents, not legal, but legal documents, right? They're required to have certain things, and that's what we're talking about here. There's certain things that are supposed to be on these documents that makes them the legal document, a lawful. It's full of law, right? The law dictates what has to be in that document, which is a court seal, the actual name of the man, their official job title, and an actual signature. Now, I cut him some slack with the digital realm of things, but court seal can't be done digitally. It needs to be, that sucker needs to be real, and it should be raised. Should be
That
a
is
raised
correct.
seal or embossed in some way, like this one here is. You can feel that this, indentation on the paper itself.
Mhm.
All these crappy ass fake documents they're creating, they're garbage. They're junk.
Well, I mean, and that's really in essence one of the things one of the many things we're having a problem with is we are, here's from Nate's case. I don't know if you guys can see that or not, but this comes from U.S. Congress, from his representative. So I don't know if you can read that or not, but there's the document. So one such example of a raised seal, this goes back a long ways. I done just for purposes, just for the show. Here is a version of a raised notary seal.
There you go.
If you can read that. Okay, that's my raised notary seal. I also have on a couple of them hanging up on the wall that Florida state seal. I have the Florida state seal as an embosser, the same as my notary seal. So that's what the embosser looks like. And all I have to do is just, pop the seal out, just change to the different seal. This one is my notary. The other one is the state seal. And I just, pop that little rascal right back into the machine and go to work. So
you've got a Florida state seal?
Yeah.
Nice.
Yeah. And so
not just your notary seal, but I'm talking about a Florida state seal.
Yep. And it looks like, let me blow it up here, for lack of a better expression. It's this one.
Wow.
But it's just like my, just like my notary, my raised notary seal, my raised notary embosser.
Mm-hmm.
It looks just like this. So that's part of my kit.
The color and everything too?
No.
I'm like, man, that's one hell of an embosser.
Right? No, it doesn't do the color. That colored seal comes from the state, the Department of State from Florida. Right. So that's the only way to get the colored one, at least that I'm aware of. So, that's in context of practice, for lack of a better expression. See the courts.
So is this you're acting under your straw man, and that's your sovereign one over there?
Even got my straw man hat on.
Well, you got, I don't know. Is this your other computer, Sovereign?
No. That's Savi.
Oh, okay.
Yeah. So he's popped in to say, hey, join us for a Monday night.
Right on.
It's been so long since we've done a Monday night show. I figure, what the hell? With that writ of deceit, you got to probably end up with a bunch of people filing that thing into their court, not realizing it says in the office of the county commissioner. Remember, if you're going to claim deceit, and how you know that again, the court's the friggin' crime scene. So we already know that. We don't need to confirm that. So you go into your legislator and you inform your legislator of the deceit, okay, and what the trespass was. You've just begun due process of law at your local level. So before, we had a bunch of people going out and actually filing a bunch of writs of deceit into the courts, basically walking in and saying, fuck you, I know you're a lying sack of shit, and getting themselves in a bunch of trouble.
Right.
It's no. You file this in the place where you have all the lawful standing, which is the body politic. So I wanted to make sure I clarified that, because I don't want anybody getting themselves into a heap of shit. So, but
y'all can file whenever you want to do up your own paperwork and file it.
mm-hmm.
Question over here on Zoom is that when can we file it? You can file this anytime you want.
Right. Yeah, there's somebody just sent me a picture. Douglas just sent me a picture of his that he's showing, he sent pictures through Messenger. We can't share them from, because I don't have this computer hooked up, but what he's sending is this thing I just showed, this raised seal, that one. He sent me a copy of what looks like his. It's hard to see the picture because it's, how pictures are. They never appear on the screen right. They look like to us, we because we took a picture. Oh, fucking you not read that. Hang on a minute. Get my eyeballs on here and wait a minute. Nonprofit seal, January 25th, 2018.
Get my eyeballs on.
Is that Nevada? That could say Nevada.
It does say Nevada.
Yeah, it is Nevada.
January 25th, 2018.
Is that Trinity of Life Church? Is that what that says?
Yep. Nonprofit seal.
All right. See, when I actually put my eyeballs on, I can actually read it, because reading does mean reading. I hate to be the bearer of bad news, folks, but reading does mean reading. Yes. All right. Oh, that was pretty cool. So, you shared it. Sweet. Awesome. So,
Yeah.
my eyeballs on over here where they belong. So let's see here. What else do we got? Something is off. Having problems with audio. Also won't allow me to post. Huh? That's okay. I was shadow banned a little while ago. Cheryl sent me something in the email today. I posted it. That writ of replevin, that one I filed into the court, that sucker was shadow banned from her page for some ungodly reason. It's not like she's not a member of the group, so she should be able to see it.
Right.
Is there something in the files to serve as an example of how you dispute those things? Which things, Myra?
Jeez.
Cynthia, if your video froze, refresh your page, darling. That might help. I have to do that over here a lot. No seal. Okay. Again, take a copy of the document. So, again, because there was so many lies and there was so much bullshit in my case, I just found in the big book, here, that writ of deceit, right? Because there's so much of it in my case. It was just, it's so much so to the point that it's self-evident because, as Kirk has said, I've gone through and properly established my record, followed due process, informed all the branches, and all of those things that I know how to do, which I'm trying to help you guys learn. So you can do this is, if I were you, I would take some version of that deceit writ, whether you want to question the other actors standing or whether you don't, whether you want to, if you have a guardian ad litem and you want to remove the guardian ad litem, that principle is part of is on the page. There's actually two, the Beauvair's Law Dictionary and the Black's Law 4th edition. Those are in the files. So you can search those different Latin legal principles that I found in this book. Those are not in the maxims section, by the way, in the back. Those are actually in alphabetical context. Decusius is actually on page 518. Like I said, I actually bookmarked it because, in context, because there are multiple ways. There are obviously and more principles of law that begin with the letter D. So, I just happened to, as I was going through, Duma. Let's see. Let me go into, let me find another letter here for, here we go. Gestio, Gestio, which is Latin or Roman law, two definitions of, or which are number one, behavior or conduct, and number two, the management of a thing, especially a transaction. So if you're going to question a transaction, such as an order, you could use gestio as to go after the management of a thing or a transaction, or if you want to question the behavior or the conduct of the actor who wrote it, coming from the 16th century out of Roman law. If I'd have known the answer, if I'd have known you were going to ask that, I'd have had that on the screen for you. And to do a screen share. Too bad I don't have a camera attached to my glasses where I could just look at this stuff and, you guys could see it. Do a screen share of my eyeball view. That would probably be scary, wouldn't it? I think everybody would probably freak out over that. I would freak out over that if I were you. Give me nightmares. Let's see. I don't know if Candy's watching. Harris Exis, which is the sole heir from Roman law, an heir to the whole estate. Hereseexasse, Latin. Heir from fact. There is fiduciarius heirs. Fiduciary heir from Roman law. Person formerly named an heir in a testament, but in a fiduciary capacity, and charged to deliver the succession to the person designated by the testament, such as like what, a testamentary trust. So must make note of that one. Bring up my little Yeah. This is what doing legal research looks like, folks. Sometimes you just find yourself going through the book and you just find stuff, you know. That's why I said pick up the dictionary or just start going through, pick a letter and just start reading something that sounds familiar to you. You want to question somebody's either legal or lawful standing, and you can type into the search legal or lawful standing, standing in law, and, you know, go down through and just click search as many times and see what pops up in the, you know, in the context of the PDF.
Yep.
Right.
Yep.
And that will help expedite your search for you. We've done that. So we've done that several times on the show. So.
Well, brother, I'm out.
All right, brother.
Pop in and say hi.
You bet. I think I'm going to end the feed here anyway. If anybody wants to hang out in the after show, by all means do so. We're not going to run late tonight, but I'm wanting
Run
to
late tonight. It's already.
Yeah, what the hell time is it anyway? Oh, it's
11:00
11:03. We are
9 o'clock.
way late.
And we need to catch up, Darren.
How do you want to do it?
That's what she said.
Yeah.
Isn't that what got us into this mess? Just
Right.
saying. So, all right. Well, anybody, I hope that's
Here, I'm going to send you.
I hope we oh yeah. Yeah, you got to watch out for the snake oil salesmen. There are plenty of them out there. Those are rough. So there's but I think we have oh no shit. Myra says I'm a bad influence on you guys. She says, I said word salad to someone the other day and it triggered them. They accused me of being a spy. Oh Jesus. Well, you can blame that one on me, Myra. I'll be more than happy to take full credit for that one. Oh God. All right, y'all. Everybody have a wonderful evening, and we're out. Kirk and I will at least the two of us will be back on Wednesday. We'll try to get a hold of John in the meantime.
Yeah, we'll see.
Yeah, see if we can get an update from him on what's going on in Tennessee, and see what we can come up with and keep you guys abreast on the letter of the law versus the rule of law versus the due process of law, and how those things affect each other and why. So tune in Wednesday. See you guys then. Have a great night.
Not at all. Much love.